Good afternoon, everyone, and welcome to the second part two of the practical training for project managers and supervisors. Today, we're going to be speaking regarding contract provisions, claims, and project documentation. My name is George Pallas. I'm really excited to be here with my partner, Kathleen Morley. We are both partners at Cohen, Seglius, Pallas, Greenhall, and Furman. We are a full-service firm. We have a large group of construction lawyers. This slide that's here posting right now on the introduction is giving me a few moments of bragging rights. We were just recently ranked number 6 in the nation in terms of the size of our construction group. We represent over 1,200 contractors throughout the United States, and we have 70 lawyers across 8 offices. So we're very proud of those accomplishments. So what are today, those of you who attended our part 1, we spoke about the contract changes provision and how to get paid for doing extra work. That was very well attended, and I thank you for those who attended part 1. Part 2, we're going to be talking about claims, notice and preservation, project documentation, and some very important project contract provisions. So let me start with, if I can, with our first topic, which is important contract provisions. And I want to speak to you on the first one regarding the notice provision. Every contract that you sign, whether you are a general contractor or a subcontractor, has a notice provision in that contract. And that notice provision is going to provide, just like it sounds, the means and methodology on how you provide notice to your person you're contracting with if you're seeking claims for money or time. These notice provisions in some states are very strictly construed. So what you want to do with respect to every contract that you're signing, you want to be able to review it, understand it before you start your job. You have to understand what those notice requirements are. In negotiating the contract, what you're going to seek to do is to avoid provisions, notice provisions that require very short periods of time with respect to when you have to give notice. What we've seen is many contracts have provisions that you have to give notice of an event giving rise to a claim within 7 days or 10 days, 14 days, 21 days. That's all reasonable. But some contracts require notice be done within 24 hours or 48 hours. That, frankly, is just too aggressive. And that's something that should be negotiated at the time of contract. These provisions also many times require you to provide a full account and scope of the damages that are being suffered as a result of the event giving rise to the claim. That's also very unrealistic. You're not going to know the full impact to your schedule or your costs due to an event that gave rise to a claim within 24 or 48 or 7 days. So that's something that you want to make sure you negotiate, that you just have to simply put them on notice that you are being impacted either by a schedule or a dollar amount. Many contractors now are becoming much more sophisticated in their notice provisions. They're essentially saying, and look out for this, that you need to have very strict compliance with the notice provisions. Otherwise, you're going to end up waiving your claim. And we have seen provisions in contracts that say you have to strictly comply with the notice provision. If you fail to do that, your claim is waived. You are waiving the legal arguments of course of conduct or prior practices by virtue of the contract. And that is something that is really quite scary, right? So make sure in every one of your contracts, as an effective project manager, you must know what those notice provisions are. You literally need to have a note on every one of your jobs what the contract requires. We represent 1,200 contractors. We have cases, hundreds of cases in the office. Every one of those cases all have the exact same issues. Was notice complied with? And if not, why not, right? And if it's complied with, I'll tell you, you save tens of thousands of dollars in legal fees because you avoid having to make all of these arguments that we have to do to get around the fact that you failed to comply with the notice requirements. So that's very, very important. Know what it is, and don't make us have to go and jump through hoops to get around your failure to do so. Another provision that's in every one of your contracts you're signing is the no damage for delay provision. The no damage for delay provision is a contractual term that lays out specifically the provision that says if you are delayed for any reason, you may be entitled to a time extension but you were not entitled to any money. And we know that if a job is delayed, it's going to cost you money. So what makes this a little bit tricky is that in the contracts that you're signing, there's not a big, bold, flashing light that says, this is the no damage for delay provision. They're typically not entitled that way. They're hidden, right? There's no clear standard language. So you want to take a look and read the contract to make sure that one, do you have such a provision in your contract? And I'll tell you, you do. You do. And what does it exactly provide for? So let's assume for a moment that you do have it, right? How do we get around these no damage for delays? They are enforceable provisions. Courts will look to them and they are enforceable. So what you want to look for is how do we get around it, right? So Pennsylvania, like many states, have recognized exceptions to the no damage for delay enforceability. And those deal with when there is an owner active interference, there's unreasonable duration of a delay, wrongful conduct, or some type of delay not otherwise contemplated by the parties. The most popular one is owner active interference. And that is when your general contractor or owner takes affirmative actions that cause the delay. So in order to get around the enforcement of this provision, you have to give notice of the delay, right? We just talked about the notice provision. And the notice would provide that the owner or the general contractor's active interference in the prosecution of the work has impacted your ability to prosecute the work timely. And that's something that you need to be mindful of so that when you're giving the notice, you are giving the proper notice, which is notice that is timely, an event giving rise to a delay. You're aware of it. It triggers the notice provision. And now to get around the no damage for delay clause that's in your contract, you want to give them the notice and claim that the general contractor or owner's active interference is causing your delay. And that's how you can successfully circumvent the enforceability of the no damage for delay provision to your circumstance. The next provision I want to speak to you briefly about is the distinction between a paid when paid versus a paid if paid. We often interchange these provisions as if there is no legal significance to that. And that's a major mistake. There is a big difference between a paid when paid provision and a paid if paid. And these provisions deal with when do you get paid from the general contractor or the owner, or from the general contractor, not the owner. So a paid when paid is that the general contractor will pay the subcontractor when it receives payment from the owner. Now that makes simple sense. It's very reasonable, right? A paid if provision is a little bit different. It says that the general contractor will have to get paid by the owner as a condition precedent for paying you, the subcontractor, meaning the actual payment from the owner to the general contractor is a condition precedent for the legal obligation of the general contractor to pay the sub. And let that sink in for a moment. Paid when paid, you get paid within a reasonable amount of time when the owner, a general contractor, gets paid by the owner. A paid if paid, that condition precedent language, means that the general contractor's legal obligation to pay a subcontractor is not triggered until it receives payment from the owner, meaning that the subcontractor is now assuming the risk, the credit worthiness of the owner in that project. And I can guarantee you, for all those subcontractors on this webinar, you never are thinking you are accepting the risk of the credit worthiness of the owner when you take that job. You just aren't doing that. So you need to take a look at your payment provisions and then try to negotiate a paid when provision as opposed to a paid if. When there's a paid when provision, the general contractor is afforded a reasonable amount of time to secure payment from the owner before it needs to pay you. But at the end of the day, the general contractor is liable to the subcontractor irrespective of whether they get paid by the owner. So that's what you want to try to figure out. What is a reasonable amount of time? There's no clear language on that. There's no clear case. It really depends on what the actions the general contractor does. If the general contractor takes no action, to recover the money from the owner, that time is very short. But if the general contractor is very active in pursuing claims against the owner, pushing to try to get paid, the courts will give the general contractor a lot of leeway in that regard. If the general contractor is litigating with the owner to try to get payment, then the courts will look to you as a sub and say, listen, you have to give the general contractor a very wide berth in terms of what's a reasonable amount of time before the general contractor is legally liable to pay you. But the bottom line is, when you're negotiating your contracts, make sure you observe the paid if paid language, which would include the language condition precedent, and make sure that you are willing or not willing to accept that risk. If you see that language in your subcontract, you want to try to negotiate it to a more friendly paid when paid provision. Let me move, if I can, briefly to liquidated damages. We all know what they are, right? They're a provision in your contract that says if you're the cause of delay, there's a fixed amount of damage that will be assessed against your contract because of that delay. Many of you on the phone, whether you are a general contractor or a subcontractor, will assume that those provisions are automatically enforceable. They are an enforceable provision. However, there are arguments why the amount set forth in the liquidated damage, the amount set forth in the contract, is in fact not enforceable. The law does not allow the imposition of a penalty by virtue of a breach of a contract. So the question is the contract, is the liquidated damage provision considered a penalty, right? So if it's a penalty, it's unenforceable. So how do you make that argument as to whether or not the liquidated damages can be assessed against you due to delay? Well, you see in that slide that's in front of you right now, liquidated damage clauses are valid and enforceable, true, if the fixed sum provided is, at the time of the contract, and here's the key, a reasonable forecast of just compensation for delay, of which some will be incapable or difficult to assess accurately. What does that mean? A reasonable forecast of just compensation for delay. It means at the time of contract, the upstream entity, the owner or the general contractor, had to have performed a reasonable forecast of what their damages would be in the event of delay. If they did not do that, there's a very strong argument that the liquidated damage amount is just something they picked out of the air. And I will tell you, general contractors and subcontractors on the phone, 9 out of 10 times, that amount of liquidated damage is just because the owner used it on another project, or it's because the design professional typically puts $1,000 a day. And there's in fact no effort made by the owner or the general contractor to reasonably forecast what the damages would be in the event there was a delay on the project. And if you can establish that, and we have done it countless times, those liquidated damages are unenforceable, right? So just because you have an LD provision doesn't mean that that amount can be assessed against you. Also, liquidated damages cannot be assessed against you if you're not the cause of delay. And Kathleen will be discussing that. But if the delay is caused by entities other than yourself, then you're not liable for any liquidated damages. Just because the job ran late doesn't mean that you get assessed liquidated damages. So there are different ways to push back on the imposition of liquidated damages. The next provision I want to speak to you about is what they call a waiver of consequential damages. This is a common provision in the contract. And what it normally says is something to the effect that if there's a breach of contract, a party is not liable to the other for consequential damages, which would be indirect damages arising from the breach of contract. That would include such things as lost rents or lost profits or loss of use of the building, things of that nature. The courts have found that some of those consequential damages may not be foreseeable at the time of the breach, and therefore they can't be enforced. So what you want to make sure is that there is that the waiver of consequential damages is what they considered mutual. That is, it's not one-sided. So if there's a mutual waiver of consequential damages, that means both sides are agreeing at the time of contract not to assess liability against the other for any of these consequential or indirect damages. Okay, so that's something that's make sure it's mutual. It is more difficult for an owner. They give up more, frankly, than a contractor does. So you definitely don't want the owner just pushing that down onto you. You want to make sure that it's mutual. Finally, I want to talk to you about the dispute provisions in the contract: litigation, arbitration, mediation. Now, most of you know what these things are, right? Litigation, you've seen TV shows with, it's in the courtroom, whether it's with a judge or a jury, and that's fine. Arbitration is a little bit more informal, but it is a formal process. In arbitration proceeding, there's lawyers on both sides. There is a panel, either 1 to 3 panelists that will hear the testimony with evidence and will make a final decision. There are no appeal rights in arbitration, but it is something that's done in a conference room, typically, or in some other non-court format, and then you get to a final resolution. Mediation is non-binding. You sit in the room, and there's a third party, typically one person, that is trying to help both sides mediate their dispute to find common ground for a resolution. What's so important about this is that each of these, the mediation, arbitration, or litigation processes, all is the time in which you put your best foot forward, and so you can advocate for your position. So all of the issues with dealing with project documents, and I think that we're going to talk about later, are critically important, because you're going to need to be able to present these documents in what we call the big show: litigation, arbitration, or mediation. When you're looking at your dispute provisions in your contract, make sure that you're not dealing in a situation where they're going to try to get you to agree to have a forum to dispute your issues somewhere other than the state in which the project is located. That often happens when you have an out-of-state general contractor coming into your state for a project, and they have in their form subcontract agreement that if there's a dispute, it has to be litigated or arbitrated in Colorado. And they figure if you allow that provision in your contract, if it's a relatively small dispute, small dollars, they think that you will not chase them in Colorado to chase that money. They are enforceable provisions, so you want to be able to do that. To be careful. Thank you for that presentation on the contract terms. We're now going to switch over to claims and claim types.
Great. Okay, thank you, George. I just want to make a note to everyone. I meant to let everyone know this at the outset. If you do have any questions as we go, you can enter them in the question and answer box, and we will do our best to address them either as we're going or at the end of the presentation. Okay, so let's talk about claims and claim types. With every construction contract, it is very rare, if not unheard of, that there won't be issues that ultimately lead to a claim, whether it be for time or money or both. So recovery of those claims is dependent upon the contractor or the subcontractor being able to substantiate and support those claims. So it's very important from the outset that we understand, as contractors and subcontractors, what we need to be compiling to be able to substantiate and support these claims. So as we are moving through a project, you want to make sure that you are creating, you're locating, and you're compiling all of the pertinent documents, correspondence, photos that you may need down the road to substantiate and support these claims. So let's talk about how we need to do that. So just generally, before we get into the documentation and the different types of claims, it's important to understand that claims are not always just about what claims can I put forward to recover additional sums at the end of a job. They're also very important for purposes of negotiating at the closeout of a job. Oftentimes the owner or a GC is going to have back charges that they're going to try and assert against a contractor or a subcontractor. So just by having these claims that you have put them on notice of, you've tracked, and you've compiled the necessary documents, when you go to close out the job, those will be important as for purposes of negotiating offsets to back charges that might be asserted against you. So it's important for that purpose, in addition to recovering rightful sums that you are owed and incurred throughout the job. So when you are deciding whether or not to pursue a claim, it is often, there are often multiple factors that come into play, and the decision ultimately should be made by senior management, and they will look to various reasons, including economic or political reasons in dealing with whoever you're dealing with, and who you contracted with. So, but it is important regardless that you are able to, and project managers and supervisors in particular, are able to recognize potential claims early in order to take the necessary steps to preserve and support them. So what is a claim? You're going to want to look at your contract. That's George spoke about that you want to make sure you look at the notice provisions and understand what those are. You want to look at your contract also and the provisions there and how they define what a claim is. This is an excerpt from a standard AIA format contract. There, a claim is defined as a demand or assertion by one of the parties seeking as a matter of right, an adjustment or interpretation of contract terms, payment of money, extension of time, or other relief with respect to the terms of the contract. The important thing to understand there, if you look at that language, it's very broad, and a claim can pretty much be anything. So it encompasses a lot, and the language there defining a claim is often very broad. So let's talk about schedule impacts. These are schedule impacts can lead to a variety of types of claims. Delay, inefficiency, and acceleration claims all involve determining who ultimately controlled or was responsible for a particular schedule impact, and how much additional time or money should be granted to the impacted contractor or subcontractor as a result of that scheduling impact. With respect to delay claims in particular, this Bruner and O'Connor is an authority that's published on construction law that is often cited to by lawyers in the construction context. And in this provision here, they've talk about delay claims and define them as an unexpected schedule impact that causes your work to take longer than originally anticipated, increasing your costs and stopping you from meeting your contractual deadlines. So that is a typical delay claim that you might have when you're impacted, and as a result, you're going to incur additional costs, and you're going to be prevented from meeting your contractual deadlines. So depending on the type of delay, you may be able to get an extension of time to perform your work and or additional contract funds to cover your increased costs. There are various types of delays and different categories of delays, and depending on in which category a particular delay falls will determine whether you are entitled to additional time and or money or neither. So the first type is a non-excusable delay. With those types of delays, the fault lies with you, and so no compensation will follow. You're not going to get an extension of time, and you're not going to get additional compensation. An example of that might be if you yourself fail to sufficiently man the project despite having labor available to you. That would be an example of a non-excusable delay. The fault lies with you. You had available labor. You didn't supplement your manpower to make it sufficient. Therefore, any delays that result, the fault lies with you. You're not going to get additional compensation as a result of that. The second category would be excusable but non-compensable delays. So with these types of delays, no one is at fault. You'll get more time, an extension of time, but you're not going to get any money. So they're excusable, you'll get the additional time, but they're non-compensable, so you're not going to get an additional money. An example there would be very abnormal weather conditions that cause delays that no one anticipated. There you will get an extension of time, but you're not going to get additional money. The third category would be excusable and compensable delays. So here, the fault lies with another party. Maybe you're a sub and it's the GC, or it's another subcontractor of the GC that caused the delays. So the fault does not lie with you. You're going to get additional time and additional money if you can prove it, that both of those, if you can prove that the fault lies exclusively with another party. An example of an excusable and compensable delay might be where design changes are implemented on a job, and those result in delays to material submittals, fabrication, and delivery. that would be an example of where that would be excusable and compensable type of delay if you can prove it. So what's important to keep in mind with respect to delay claims, the key to measuring the impact of any delay is knowing the job's critical path. The critical path is defined as the longest path through the network of identified and logically sequenced construction activities that establishes the minimum overall project duration. So in order to understand the impact of a delay, you have to know the project's critical path at any given point in time. So here is a court case from a federal court where they said that some items of work are given no leeway and must be performed on schedule. Otherwise, the entire project will be delayed. These latter items of work are on the critical path. A delay or acceleration of work along the critical path will affect the entire project. So if there's a delay to a critical path item, that will have an effect on the entire project and the substantial completion date of the project. So when you're thinking about the critical path, an event that disrupts work not along the critical path, on the contrary, those will not be recoverable as a claim for delay or acceleration. You may have an inefficiency claim because it's still a delay to a non-critical path item. That might result in inefficiencies. Your work may be less efficient and therefore you might be able to seek efficiency costs or loss of efficiency, but you're not going to be able to recover a claim for delay or acceleration because that event did not disrupt the work that was along the critical path, and therefore the project end date is not going to be affected. So what are some of the types of causes of delays? There are all types of things that can cause delays on a project. Some of those are listed here. Failure to have site access or only having limited access to the site. Any unforeseen conditions at the job site that you weren't anticipating. Circumstances that make it impossible to perform certain work. If there are design changes that are implemented, those can certainly result in delays. Failure to have shop drawings or samples prepared or approved in a timely manner. Also, failure to have material and equipment delivered in a timely manner. Other causes of delay, acts of God like floods and severe storms. Weather can certainly cause delays. Strikes and labor disputes, low productivity, cash flow restrictions, lack of project coordination, labor mobilization, or just delays by other trades or contractors on the project. So there are many different causes of delays on any given project. The costs associated with delay, what are some of those? If you experience delays, some of the costs that can be incurred include extended job supervision and field overhead costs, extended equipment costs for having them on the job for a longer period of time, wage escalations. The wage rates can escalate during the time of the delay. You're performing your work at a later time than you anticipated. Finance costs, inefficiency costs, reduced job opportunities on other projects. You're on this project longer. Profits, you can lost profits. So some of the questions that you might be asking about delays, or you should be thinking about when you're facing delays on a project, you want to be thinking about, particularly as a project manager or supervisor, you want to be thinking, how do I need to notify the owner or the general contractor of the delay? Should my notice include the identification of specific work areas that are impacted by the delay? Should your notice identify the manner in which you are being damaged by the delay? Also, how do you quantify days of delay? These are some of the questions that you might be asking yourself as you encounter these delays.
Kathleen, if I can jump in real quick, so people, those questions that Kathleen raised are absolutely critical, right? You should be asking yourself, people ask themselves often, how do you do that? Well, you know the answer. It's intuitive, right? How do you notify the owner or general contractor delay? You do it in writing, because your notice provision that we just talked about is going to require you to do that. If there's an event giving rise to a claim, that triggers immediately the notice provision. So how do you notify? In writing. There is no other way that is acceptable. Should your notice identify the specific areas of work impacted by delay? Of course it should, right? The notice should be very specific. I am being delayed in this area of my work because of this reason. Should they identify the manner in which you're being damaged by the delay? Yes, because of this obstruction that I'm encountering, I have manpower standing around idly, and that's going to continue being the case until this issue is resolved. How do you quantify the delay? The best you can. While that condition causing the delay is in existence, I am being delayed day for day. All of that information should be disclosed, but why? Why should it be disclosed? It should be disclosed because you want your upper tier contractor or owner to fix the problem. This is not, it's not trying to catch somebody in a mistake. You're trying to cooperate. I'm putting you on notice in writing about what's impacting me and causing me delay so that you can fix it to mitigate that risk and mitigate the damage. That's why the law wants you to provide them notice so that they can fix that condition. Thanks, Kathleen.
Yeah, sure. Those are great points. And we have a couple questions here that I believe relate to delays. So let's try and see if we can address some of them. We have a question that says if we've hit an obstruction and not only the actual equipment performing the work is disrupted, but ancillary equipment is also affected, the ancillary equipment is not deemed a consequential damage or an indirect damage, is it? Also, if the schedule is extended, the indirects, i.e. job site overheads, are also direct costs and not consequential. Correct? George, do you want to address that?
Sure, absolutely. So if you're going to encounter an obstruction, right, that's going to impact your work, the actual equipment being used or any ancillary equipment that's on the project that is being impacted by that obstruction is considered a direct damage. I would not consider that to be an indirect damage whatsoever. And if the schedule is extended as a result of the obstruction, that's not, it was unforeseen, all costs associated with that delay would be considered, I would argue, a direct damage to the project. And then for you to be entitled to recover damages associated with it.
Agreed. Another question, what if my sub delays the project? There, if it's your sub or your sub, you can be held responsible if it's causing delays to the project and you're a sub to a GC. The GC could try to hold you liable if that's your subcontractors that are working underneath you that are causing delays.
That's right. Absolutely. You own the conduct of your subcontractors for sure.
And must the schedule and definition of the critical path items be included in the contract for the contractor to be liable?
No. See, what happens is when you get that base contract, many times it's not going to specifically identify the critical path. It depends on the sophistication of the contract schedule that's attached to your contract. If you can show us the construction activities with zero float, and it's specifically identified, you can probably map it out. But many times, many contracts are not going to highlight for you the nature and identification of the critical path. That's unfortunate, but that's the truth.
Yeah. Okay. We will keep moving. All right. So you want to look at back to delays. You want to look at what your contract requires. See what type of notice provisions. George talked about the notice provisions. You want to understand what your requirements are when you do encounter a delay. What types of things are you required to do under the contract to notify the GC or the owner of these delays? And at the questions you should ask yourself as a project manager or supervisor at the end of each month to get yourself thinking about delays that may have been encountered in the preceding month. Are we following the original schedule? If you're not, ask yourself, why are you not? Is it something that we are responsible for? Then if we are, we need to try and address that and fix that on our own. If there's a reason that we're not on the schedule and that's the result of actions or inactions by either the GC or the owner or some other trade, then we want to be aware of that and think about what you need to do about that and take the appropriate action, send the appropriate notice, put them on notice of the delays that you're experiencing. And as George said, you want to give as much detail as you can at the time to try and identify specifically what's being impacted, to what extent, and what kind of consequence that's going to have on you. You don't want to assume anything. You want to take actions each month at the time these delays are arising to protect yourself under the contract.
And Kathleen, keep in mind, everyone, this all kind of ties together, right? So every month you should be asking these questions. And when you ask yourselves these questions, obviously, if the reason why you're behind schedule is because you're not doing something right, well, then fix it, right? It's
Sure.
your problem, fix it. If it's your subcontractor causing delay, that's your responsibility, fix it.
Right.
But if you're being delayed because of somebody else is imposing something on you, that automatically, remember, it's an event giving rise to a claim, which triggers the notice requirement of your contract, and you have a no damage for delay clause in your contract, most likely. So you then have to create the notice to get, and if it's not your fault, to get around that no damage for delay clause by specifically identifying it was the GC's or owner's active interference that caused that delay. That's why every month you have to be asking yourselves, where are we on the schedule, so that you can either address it, an issue that's your problem, or if it's somebody else's problem, issue the appropriate notice to get around that no damage for delay. That's why it's important to do it at least once a month.
Exactly. So here, you guys will all get a copy of these slides, but here we include an example of the type of correspondence that you could send, or a template for doing so, where you put them on notice that the language here, our contract requires us to put them on notice whenever our work is being delayed or impacted. We don't want to be adversarial, but we recognize the need to adhere to the terms of our contract. So as a result, we feel to tell you, compelled to tell you about the following conditions impacting our work. And then here in this example, it's saying that you will provide the cost consequences of these impacts at the completion of the project. So this is a sample template that you can use to identify on a monthly or more frequent basis of the impacts that are being experienced on the job.
And everybody on the webinar, keep in mind, we hear this all the time. Geez, if I put these notices out, I'm going to really piss off my upper tier contractor. I don't want to be adversarial. I'm going to create a claim environment. Keep in mind, the notice provision that's in the contract is there because the upper tier, either the owner or the general contractor, wants a notice provision. You are contractually obligated to provide the notice. So that's why that form letter that Kathleen put up there is a very friendly one. You could even say it even nicer. I hate to, dear John, I hate to really bother you with this. I really don't feel uncomfortable doing it. I really don't want to do it, but I'm forced to because it's in my contract. That's why I'm telling you about these conditions. So please do not get hooked into this notion that if you provide this notice, somehow you're doing something wrong. It's quite the opposite. You're doing something wrong if you don't send the letter. Be as friendly as you like,
Yeah,
but send the notice.
That's a great point, George. Thank you. Here is another example of this time in a memorandum type format. This is in the example here is with respect to an electrical sub. And this is something that you can use as a project manager or supervisor to try and compile and memorialize on an ongoing basis in as much detail as possible some of the unexpected restraints or impacts that you're experiencing on different, with respect to different activities and in different locations throughout the job. So this is just a different format that you could provide to the general contractor or the owner to put them on notice of the various activities and locations where you're being delayed or what the status of those delays are. So this is just another example of type of documentation that you could create and maintain on the job. So that was delay claims. We're now going to talk about, in particular, acceleration claims. So what are acceleration claims? Acceleration is the speeding up of the pace of your own work or compressing the contract time in order to either achieve project deadlines earlier than you were supposed to, or to recover the schedule due to prior delays, either due to the contractor or predecessor work. So it's either you're trying to accelerate or your work, the time to complete your work is compressed, either to meet earlier deadlines or because you haven't had as much time to complete them because there have been other delays. Because the contractor has less time to complete its work, in order to do that, it has to increase its labor and equipment use with overtime or additional crews. So that results in, of course, additional costs. There are different types of acceleration. one of which is directed acceleration. That's when it's confirmed in writing, either by a change order or a written directive from the general contractor or the owner that expressly directs you to accelerate your work. That's pretty straightforward. When they put it in writing, they're directing you to work overtime, to add additional crews, to get the work done faster, or that they're not going to give you an extension of time when there have been delays that have already occurred. When there can also be constructive acceleration, and that's when it's implied due to certain actions, when certain circumstances arise. So when does constructive acceleration arise? When there are excusable delays that are incurred. So we talked about what excusable delays were. Those will be delays that you yourself did not cause. And then you request an extension of time and it's denied. That's the key point here. If you experience, there are delays that are not your fault, you feel that they're excusable under your subcontract, your contract terms, you need to request an extension of time. Even if you know it's going to be delayed, even if you expect it's going to be, or denied, I'm sorry, even if you expect that it will be denied by the contractor or the owner, you must request one and have it be denied. Then if the owner expressly orders completion within the original performance time, or the contractor gives notice to the owner that its actions constitute constructive acceleration, those are the grounds for arguing that your work has been constructively accelerated. So there were delays, you asked for an extension of time, you didn't get it, and therefore you want to put the owner or the GC on notice to say, there were these delays, I requested an extension of time, it was denied, so we are understanding this and treating this as being constructive. We are being asked to constructively accelerate our work. We are going to submit a claim at the end for the additional costs of doing so. So we'll show you an example letter that you can send when that occurs. What are the various causes of acceleration? It can be a decision or a directive by the general contractor, the owner, the architect to finish the project early, to finish part of the project early. A delay or stop by the owner with no extension to the finish date. So there were delays, stoppages in work, but they're holding you to the same finish date. Failure by the owner or the engineer, architect to grant a valid time extension that we talked about a moment ago, or a directive by the owner to man the project at certain levels, asking you to increase, supplement your workforce. What are some of the costs of acceleration? If you do have to accelerate your work, what are some of the increased costs that can result? Those would be those relating to overtime work. You can have inefficiencies that result from accelerating your work, costs of expediting vendor delivery, additional supervision and overhead, and it can lead to reduction in equipment rental costs due to the fact if your time period is compressed and you don't need that rental equipment as long as you thought you were going to need it. So how do you preserve a constructive acceleration claim? This was the point we spoke about earlier. It is critical that you must ask for a time extension. What should you do then if the owner denies the request for extension of time? Here is a form letter that you can follow and you should send in those circumstances. Here, this is a perfect example. You're writing to put them on notice that we're being delayed by reason of the acts of blank or its subcontractors. You give an estimation. At present, the job is this many weeks behind schedule. Our price in the subcontractor was predicated upon a blank week duration. Therefore, our work is being accelerated and our durations compressed. As a consequence, we request an extension of time of this. If you refuse to give it to us, we will have no choice but to consider this refusal to be a constructive acceleration. And then you go on to state that additional costs incurred to achieve the compressed schedule will be maintained and submitted daily for signature. And at the conclusion, it will be presented as a COR or a claim for the increased cost. So this is an example letter that you would want to send when these circumstances occurred. You're facing these delays, you're requesting an extension of time. If they're not going to give it to you, you're going to treat this as a constructive acceleration of your work, and you will track and submit the costs accordingly.
And everyone on the webinar, please do not get sucked into a false sense of complacency. Many times owners or general contractors will make it very clear that this project will not accept any extensions of time. We have to get the school open on time. We have to open that plant, get it online on this date certain. I got to open that casino by this certain date. No extensions will be granted ever, ever. Okay, that means nothing. From our perspective, if you are being delayed, you must ask for a time extension, even if you know they're not going to approve it. It's irrelevant. You ask and they deny it. Ask 100 times, have them deny it 100 times. It doesn't matter. In order to preserve a constructive acceleration claim, you must ask for the time extension and it must be denied. Okay?
Exactly. Okay, so now let's talk about inefficiency claims. This is the third type of category of schedule impact related claims. So inefficiency claims, those are when your planned productivity has been affected through no fault of your own. It can also be referred to as a disruption claim. These are different and distinct from delay and acceleration because it involves both critical and non-critical activities. We spoke about before that there might be activities that are non-critical to the project, therefore they're not going to extend the end date of the project. However, they can still result in inefficiencies to your work that could lead to inefficiency claims. So these inefficiency claims, they can arise as a byproduct of delay or acceleration, or they can result from other labor inefficiencies. Primary causes of inefficiencies are performing work out of sequence, stacking of trades, performing overtime work, accelerating your work, restricted access to work, or the combined effects of change orders, RFIs, or design changes. Your work can become inefficient if there is, due to the volume, if there is a large number of design changes, a large number of RFIs that are issued, a large number of change orders to your work. The combined effects of those can result in inefficiencies. And any of these other items that would result in your work being performed at a less efficient rate. Examples of loss inefficiency. Here's an example to highlight what a loss of efficiency claim might look like. So if there's certain structural steel erection that's expected to take the erector 4 weeks to complete, according to the schedule, the activity was supposed to take 1,400 labor hours. However, because of the concrete contractor's interferences during the first 2 weeks of that, the steel workers could not consistently access the work. As a result of the congested environment, the activity now takes 2,100 labor hours to complete. That's a 700-hour labor overrun, which it means that it's a 50% loss of productivity for the steel contractor.
So we often, the inefficiency claim is one of the most difficult claims to prove. Think about that. How are you going to prove that your labor hours increased? Well, in the aggregate, you could say, well, I planned on having so many labor hours for the job, and therefore I ran over, and therefore I was running inefficient. As that's very difficult to prove causation. So what's the best way to do it? The most sophisticated contractors break out their estimates in with various job cost codes, right? And they have their field superintendents or foremen charge a labor hour to the particular activity. And this way you can track the labor hours expended for each individual activity each month. So when every month you're getting together to find out where you are on the schedule, you should be also looking at your job cost reports to say, we had budgeted in our estimate 1,000 man hours to do site excavation in the west wing. After the month, you track, well, we've already expended 30% of our budgeted labor hours for that excavation, but we're only 10% complete. That will indicate to you, well, we're running over. Why is that? Is it because our estimate was bad? Maybe, or maybe because you encountered unforeseen conditions that's causing you to work more difficultly on the site. That would then trigger the notice sending out to your upper tier. So if you can break out your various construction activities to specific, broke it down more detailed and track it accordingly, you can really zero in on what is in fact where you're running inefficient and then what the cause of it, what that cause of the inefficiency. So in the last 10 minutes, let me just speak to you briefly about project documentation. All right, so we know what project documentation is, right? And it's critically important. for claim preservation. And there's a host of documents that you're all familiar with. The most important document in your project file is your contract, and that deals with, of course, having to negotiate the best terms that you can. And we spoke a little bit about some of these terms. The second most important document in your project file is your daily report. And I know what many of you are saying, oh, it's a pain in the ass to try to get these guys to record daily reports on any thoroughly or completely. Well, if that's the case, you're missing a huge opportunity to protect yourself and to advocate for yourself. It's something that needs to be done training at the field level, because the daily report is a contemporaneous writing, which is recording what the observations are on each day. And you know why I say it's the second most important document in your file? Because the law assumes that if you observe something and then write it down, that you did so accurately. So it becomes the Bible. No one remembers what they did June 3rd of last year, but what happens is you pull out the daily report on June 3rd, and that is exactly what happened on June 3rd. So do not miss the opportunity to force your people to have very good daily reports. Train them. As a project manager, you want that information clearly stated, in the form. Note where the crews are working. Note any type of problems are in the field. Note important conversations. Many times your field superintendent is going to have a conversation with the field superintendent of another trade. And in that conversation, the other trade's field superintendent is going to say, they're having problems for the following reasons. That daily report, if it's recorded, you'll be able to testify to it when you're at the big show: arbitration, litigation, mediation. This is all the evidence that you need. Document the weather. Make sure these daily reports do not satisfy your notice requirements unless the daily report is actually handed to the general contractor or the owner. In some contracts, that's a requirement, but not all. Mostly, it's not required. It's an internal document that you need to be aware of, and it's a great opportunity to be an absolute good advocate for yourself. You should document where materials are delivered, discrepancies on the plans, deviations in the schedule, describe out of work. It's an opportunity to keep track on a daily basis what's happening in the field. So that if there's a problem, a year later, you'll be able to tell you exactly what the problem was, where it occurred, and why it occurred. The only thing that's better than a daily report is if the entire job from every angle was videotaped. If you had a constant camera crew around you, every aspect of the job, then the daily report wouldn't be needed. But we don't have that yet. So take advantage of these daily reports, critically important. Here's a sample of one that we've given. Those of you who have difficulty, this might be a little checklist that you could provide. It gives you some assistance. So you should take a look at it. Correspondence. We talk about that. We've given samples. Kathleen's shown you a bunch of samples of correspondence. Be an advocate for yourself, right? Construction is unlike most commercial disputes. You're able to create your own evidence. I'm confident right now, everyone on this webinar, and there's about 400 of you, could leave this webinar right now at 1 o'clock. On every one of your projects, write an email or letter talking about something that happened that you want to get off your mind. Well, guess what? That document, that email, that correspondence is going to be an exhibit in your big show: litigation, arbitration, mediation. So really, there is no excuse that if you're in the big show, geez, I wish I had some writing that said this or that. You can create that writing today. Even if it's late because you missed your notice requirements, prepare it, get it in. The letter does not have to be adversarial. And I strongly recommend never having emails that are strongly adversarial. Many times clients are so heated in the moment, they'll write in bold caps, underline, will use disparaging language, will curse, will use a foul language in their writings. You can't do that. Why? Think about it. In the big show, I'm going to have that project manager or field superintendent in the stand making a presentation. And that individual is going to be cleaned up, clean shaven, wearing a sport jacket, wearing the appropriate cologne, looks like $1 million, is going to deliver a beautiful presentation. And then on cross-examination, You're going to show letters where the individuals cursing, using foul language, using inappropriate language. And you know what happens? That person's credibility goes right into the toilet. It looks like you're a liar. It looks like you're a jerk. And I will tell you, at the big show, our juries, judges, arbitrators, mediators, they don't like jerks. So be factual, don't be adversarial. Provide the notice, cite to the contract where you're obligated to do that. And that's okay. Defend your position. No, absolutely. If someone writes to you and says you're bad for these reasons, you have to respond, because the law is going to assume if you don't, that you agreed with them. So correspondence, critical document. Meeting minutes. You go every month to a job meeting, and there's meeting minutes prepared by somebody, the architect, the owner, the general contractor. And many times you're at these meetings and you're standing up, you're raising your hand, and you're complaining about this or that, some obstruction, some interference, something's in your way. Then you look at the meeting minutes, they're not there. Your issue is not reflected in the meeting minutes. But you're allowed to send a letter, an email, to the author of the meeting minutes. Hey, at the meeting last week, I said the following things that aren't in the meeting. Please amend your meeting minutes and republish them. Are they ever going to do that? No, they're never going to do that. Do I care if they don't do that? No. Why? Because your email is a written document indicating the modification you are seeking. So I don't care if they change the meeting minutes. Your email will be all that you need. I can't tell you how many cases. I'm in one right now. There's meeting minutes every week. And I'm there saying, well, it's not what you're testifying to. It's not in the meeting. And you it didn't make it in the meeting minutes, but you could have modified it. Did you do it? No, I never did. And I never did. So now all of a sudden it looks like it's the guy's lying. Claim preservation is really about documentation. And I'm going to assume for a moment you did everything right. You took great notes and you did everything right. And you sent all the notices. Are you protected? Are you easily covered? No, not yet. And the reason why it is not the case is because in every time that you're signing for every month for a pay application, you're asked to sign a release in exchange for that pay application. Back in the old days, you would release liens. But now the language is much different. Now the language is you're releasing every claim. Read the release that you need to sign in exchange for your progress payment. If it says in exchange for that payment, you are releasing claims, then all these notices that you've been sending out are wiped out, right? So, Kathleen, keep move on if you're on the next slide, because I'm running out of time. So you want to read the release for sure, right? Make sure that if you have claims that you've been putting people on notice of, you have to modify the release. Modify it so it does not, that you're preserving those claims. And read it carefully. What happens if they don't allow you to modify that release? Well, then you need to sign the release as in and send a letter in that goes with it that says, I'm sending it as is, but I'm still reserving my rights. And I know we've included a couple of, we have a language here, for example, here it is. Here's a letter for your use that says, look, I'm signing this release, but I'm still reserving my rights, right? Read your releases. In every single claim that we have, we're looking at those releases to see whether the claims have been knocked out. All right, so you want to do that, okay? And this should be happening every time. So I guess at the end of the best practice here, we're talking about these claims, is every month you should be asking yourself these questions. Are you on schedule? If not, why not? These are, if you're not on schedule, if it's somebody else's fault, that triggers the claim notice that you got to send out something in writing. Make sure you do that every single time. Let me if I can just wrap this thing up. These claims are not personal issues. It's on every project, because when you bid a job, you bid it on you estimate and have a certain assumptions. You're assuming there's a bunch of things going to be that are in place for you to bid that job and to work that job. And all that you want is to build a job the way you bid it and to have no interferences. But on every single job, you have interferences or some issue. And this is not about racing to the courthouse. It's about leverage. It's about protecting yourself so that you can properly and effectively close out the job. And if you have the claim notices that are not adversarial and you can preserve all your rights, it gives you a lot of ammunition to go and close out the job the way you want to close it out and not have that be litigated. Now, I know there's a bunch of questions here that have been laid out, and I know I'm running a little bit over, and I apologize for that. But if I can go through them really quickly for you, we have one. In the case of a claim with a justified lost profit component, does a mutual waiver of consequential damages negate the lost profit? It depends on your contract language specifically. And you need to take a look at if it's part of a wrongful termination, it would be protected. But if it's not part of a wrongful termination, it depends on specifically on the language of the contract. If the obstruction causes a delay, then directly after the GC causes a delay, but is trying to recover LDs, which include the GC's delay, is there a clear-cut argument of duplicative delay? What you're referring to, Jeff, is you're talking about concurrent delays. If there are concurrent delays caused by you and caused by them, well, then there's two things that happen. They kind of cancel each other out. They're not entitled to assess liquidated damages, and you're not entitled to delay damages for periods of time that there are concurrent delays. Can I accept LDs without concern if there is no schedule in the contract? Time is of the essence in all of my contract, but never a delivery date. Can I accept LDs without concern? No, you can't accept LDs with no concern. LDs may not be enforceable. They may not be a reasonable forecast of what the damages were going to be. Did the owner or general contractor perform that assessment before you sign the contract? Without a delivery date, how is there an end date that you would measure when your work is to be completed? So if there's never a delivery date in your contract, can you accept LDs? No, absolutely not. Being a subcontractor, we often see I just lost me somewhere there, Kathleen. There was another one I was going over. All right. I did not receive, okay. Oh, and that's just, all right. So I just missed one. Let me see with that. How are COVID impacts being handled in the market? This is a changing world. Many contractors were having difficulty manning projects due to COVID impacts. Where that ultimately is going to lead out in the courts, I don't know that answer. But in the event that you are having problems manning projects because of COVID impacts, not being able to provide labor to the job, I do not believe this is going to be your issue. The question is whether it's going to be an excusable delay, not compensable clearly, but maybe it's going to be an excusable, and I don't know the answer to that question. But we do know that if you can't find your manpower to get there, you will be ultimately responsible for completion of your work, and the consequences of that we're going to be on the end of the project. From a GCN, how do you know what subs bid hours were accurate? You don't know. What you end up getting is when you do your leveling sheet from your various subcontractors, you could ask for that information, but you're not going to know that without getting the bid estimates. If I'm a subcontractor, I'm not providing you the bid estimate. It's an internal document, and it also has a proprietary information. So in the GC, you're not going to know the bid hours were accurate or not until the end of the project. Okay, did I miss anybody else? I think that's it. And we're running 3 minutes late. Everybody, I think we're good, Kathleen. Did I miss everybody? I think I got it all.
So if we missed any question of yours, I think we got them all. I didn't see the one you thought that we missed. Yeah, but if you have any questions, you can always feel free to email us directly, and we'd be happy to answer them. We got a couple questions also about the materials again, and also inquiring about the materials for part 1. Those will be available. You should have received the part 1 materials. You will definitely receive the part 2 materials. And if you're missing any of those, you can feel free to email us directly, and I will make sure you get those. But those should all be sent out promptly.
And just in my closing comments, and I know I'm running late and I shouldn't have any closing comments, but let me just say, please, 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 the writing, these notices, the stack of paper, electronically, that you have protects yourself. Do not think that you are a claims person or you are going to create a problem, because that is a fool's belief. No one doesn't get the next job because they properly, professionally identified an obstruction, interference, or something else that caused impact. The general contractor or the owner wants to hear this information because they want to correct it. If you fail to do that, at the end of the day, you will be the one that suffers. Okay. So please, please, please write. The power is in your fingers. All right. Thank you, everyone. I appreciate your time. I'm sorry we ran over 4 minutes. If you have any questions, like Kathleen said, please send us an email. We'd love to answer your questions for you. All right.
Yes.
Thank you, everyone. I
Bye.
appreciate your time.